You've written a book, you've come up with a really wonderful concept, and you've put it out to the world. But sometimes there are people that actually steal your intellectual property. It's a very real thing, and every year there are masses of cases that come through on Amazon and other platforms of people accusing someone of stealing your intellectual property. And so that's why today I have invited Claire, who's an attorney, and she specializes in copyright law, to come and chat to us about these really important topics that as authors, if we're business people, we have to pay attention to. Claire, welcome to the show.
Thank you, Kim.
So tell me, why did you want to get involved in copyright law? There's so many different kinds of law that you can participate in. Why this particular topic?
I really enjoy intellectual property, and coming from an entrepreneur background, I appreciate how entrepreneurs come up with interesting ideas, business concepts, and it's important to make sure that these don't get stolen by opportunistic third parties who listen to your idea or copy what you've written. And so I got the opportunity to do my articles at a law firm that specializes in intellectual property. And I really enjoyed the fact that you're able to be introduced to creative people, and you can see your product and your protections out there in the community, in the real life situations. You walk in a shop, you see a trademark that you filed. You look at a website, your client has protected their website. So I enjoy seeing practical implementation of the protection that people have sought.
Lovely. I want to ask about very specific things that are related to authors, because there's a lot of authors that are watching this channel. So first thing that you see when you are looking for a book is the cover. Now, some of the things that you told me kind of broke my heart when it came to the cover design. Tell us a little bit about how the law works when it comes to cover design. Who actually owns that cover?
Sure. So copyright is broken up into various elements. And one of those elements that would pertain to a cover of a book is an artistic work. Now, the way that our copyright law works is the person who is the author, the artist of the artistic work, typically is the person who owns that artistic work. So if you have approached a third-party graphic designer or an artist to come up with a design for your book, they own the copyright in that drawing that they've done for you or in that work that they've done for you if you haven't secured a copyright assignment agreement from them. So just because you pay them to do the work doesn't mean that you automatically own the copyright. It's very important to make sure that you enter into a written copyright assignment agreement with the artist or the graphic designer who's come up with the design of your book, because it's one of the very few agreements that must be in writing in order to be lawful. And that is the only way that you can then secure that you own that copyright. And the reason why that's important is that if you ever want to stop somebody else from infringing your copyright or making sure that they don't copy you, you have to make that first essential allegation. I own the copyright in this work. And if you haven't taken assignment of that copyright from the artist who originally created, you won't be able to make that first essential allegation in law. And that's why it's important to make sure that you've got a copyright assignment agreement that you've secured from the artist that you've commissioned to do this work for you.
Now, an interesting thing that's come up quite recently with a graphic designer and an author that I know about is the illustrated works. So she has come up with the concept to publish this book, but she is asking that the images are based on people that she actually knows. So one of the people is her daughter. Now, she hasn't gotten that agreement, and there is an agreement in place, but it hasn't been signed yet, and she hasn't paid for the extended use of that copyright law. Now, what happens is she decides she doesn't want to use any of those illustrations that are based on her daughter. Let's say she wants to go with a different illustrator, because that happens a lot in the book world. What are her rights then? Is it that she just has to write it off and say, all of these works were developed for me, I'm not using them, but he could technically sell that work to someone else?
You see, in terms of the Copyright Act, there is an exception to the rule that the author owns the image. And that is where they are, or where the illustrator has done a portrait of a person. So it works with photographers, or if you ask somebody to do a portrait for you. In that instance, that is an exception to the law. And in that instance, the person who commissioned the work would own the work. So in this example, your friend would still own the copyrights in the illustration of the portrait, so to speak, because she commissioned it. But if it was not a commissioned work, then yes, the original author would be the owner of that work and be entitled to use it and sell it to third parties. There is common law rights that would assist your client's daughter, for example, if she never consented to her picture being used on a cereal box or something like that. There are personality rights that you can enforce to prevent third parties from using your image or your likeness to promote a product that you haven't agreed to. But certainly are allowed to take pictures of people in public settings and, use those pictures in an article, as long as you're not trying to gain any commercial gain from using those pictures.
So another thing that has occurred is that, sometimes people, they'll write a book or they'll come up with a speech and they'll come up with a name, kind of a trademark. Tell us a little bit about trademark agreements. So within our author community and our speaker community, we've had a couple of people that have actually approached you for trademark. When is it important to actually take that step when it comes to trademarking?
So the thing with trademarks is that they work chronologically. So my answer to that is the sooner the better. As soon as you're wanting to develop a name or a slogan or a logo that is going to be important to you to distinguish your goods and services from somebody else's product, you get in touch with us and we do what's called a trademark and infringement search, where we quickly search through the trademarks registry and we see whether or not somebody has already filed a trademark that's similar to your name. And this process that we undertake is very important because trademarks are divided into 45 different goods and services. And so something like an ebook falls into class 9, but if you are selling a printed book or a printed magazine or something like that, that falls into class 16. So each type of goods and services falls into a different class, and we then search the registry to make sure to see whether or not your trademark is then available. And the process is, once we've identified that it is available, we file the trademark application. And in about 12 to 18 months, the registrar of trademarks examines that trademark application and compares it to all the other trademarks that have already been filed before your trademark. Once they've done the examination, they issue an examination report, which may be that we need to file a power of attorney, or you may need to agree to have your logo trademark and your word trademark associated with one another. Once we've complied with those conditions, the trademark is then advertised in the Patent and Trademark Journal for 3 months, where any interested party has an opportunity to approach you and say, I've been using this trademark, or your trademark sounds very similar to mine. If there's no opposition, you don't receive any of those requests, the trademark then proceeds to registration, and it's valid for 10 years, and you can renew it every 10 years. It never expires, provided that you continue to renew it. And you can file trademarks for your name, for your book title, for a logo. There's even the possibility to file a trademark for a container of goods or a sound, or even a position, a certain position. If you're going to put your label on a certain position on a garment, you can also file a trademark for that. So it's really important when you're out there trying to distinguish your goods and services from somebody else to protect yourself with this very statutory important right, which is trademark protection.
So a question that I have is, let's say the trademark is the title of my book. It is also the title of the talks that I do, and it is the title of workshops that I do. Do I have to file separately for all of them, or can the trademark include all of those aspects?
It would be very important to file separate trademarks. So a digital book is in class 9, but something like a talk or a speech can fall into class 41, which covers a class that covers education, sporting events, cultural events, and entertainment. So all of those aspects may fall into class 41. So as a speaker, you would need to file in the actual class that covers the product and then in the class that covers the service. And in South Africa, we don't have a multi-class filing system, which means that in each class, you must file a separate trademark application.
Gosh. So you could be filing it in one area, and then someone could just start doing something in a completely different area, file it in that area, and then you can no longer use your trademark. Is that correct?
Correct. That's how you have something like Cobra floor polish and Cobra taps.
Yes.
They're two separate products with the same name falling into different classes, covering different goods and services. So if you've come up with a really good trademark for your product, and let's say you've got a food product and somebody then files a trademark for that in the class that covers clothing, for example, because those goods and services are different, you would be able to have the same trademark in different classes owned by different people. There is something called conflicting classes where things are close to each other. So for example, in a class where you've got wine and food, the registrar will compare those two classes and check with each other whether or not there is a conflict and whether or not these trademarks sound too similar to one another. And that's the process that they do at the time when they examine your trademark application.
So tell me, what is the cost of not doing it?
The challenge of not, and I would suggest that you have a multifunctional approach. You want to have as many arrows in your quiver as possible. So the beautiful thing about copyright protection is that you don't have to register it anywhere. It vests automatically in the author. So from that point of view, what you want to make sure is that you've created an original work, and that you are able to prove that it is original work. So if you're going to date stamp it or send it to somebody else that shows that on the date that you created, those are important things to do, because if you ever want to stop somebody else from infringing your copyrights, you'll have to make that first essential allegation: I own the copyright in the work. And from a trademark point of view, once you've built this brand, if you are ever selling your products on platforms such as Amazon or something like that, often they give a lot of good rights to intellectual property holders, and they will ask you if you have filed a trademark application. And if you have filed a trademark application, they will note it on their site, which is very helpful if you ever want to stop a third party from also advertising their goods on a site like Amazon. If you can show that you're the registered proprietor, they will often take down that infringing trademark goods and services that is provided by a third-party proprietor. And so the danger of not securing your intellectual property means that it becomes words that are not distinctive and becomes diluted. And that's what you don't want to do. You don't want to dilute your brand. Your brand is there to be promoted and to distinguish yourself from goods and services, your goods and services from other people. And if you don't protect it, you run the risk that you will never ever be able to distinguish yourself from everyone else, and then your brand really doesn't serve the purpose of distinctiveness and just becomes totally diluted.
One of the things that I heard you speak about is in terms of trademark, that there's certain kinds of rules that whether you can use common words or words that describe what you do. Just explain that process to us a little bit.
So from a trademark point of view, what we're looking for is distinctiveness. If you are going to use words that are reasonably required for use in the trade, or words which are completely descriptive, that makes for a very bad trademark. So for example, if you wanted to register a trademark for shoes and you called yourself the shoe shop, this is a terrible trademark. Reason being is shoe is completely descriptive, shop is completely descriptive, and these are words that are reasonably required by any third parties when they're wanting to describe something. So when you choose a trademark, try to use words that are not descriptive. Red dog for shoes, for example, or Black Panther for deodorant. These are words that you wouldn't necessarily associate with the goods and services. It makes it stick out in your mind. And it's important to have these discussions with your marketing team, because sometimes from a marketing point of view, you'll find that people love to have the descriptive words so that people understand it and know what you do. But from a trademark perspective, we want your trademark to stand out. We want it to be distinctive so that it's very easy to distinguish your goods and services from somebody else's goods and services. So from a trademark point of view, please steer away from descriptive words that are reasonably required for the use in the trade. And before you launch your marketing campaign and get all your flyers and your corporate identity sorted, please check the trademarks register first, because you can spend a lot of money on building your corporate brand only to find out that the trademark is already registered by somebody else. And because the company's register and the trademarks register are not cross-referenced at the time when you file your trademark application, you may have you may think that because you've got the company name, you've definitely got the trademark, and that isn't the case. If you haven't filed the trademark application, you haven't secured the trademark. You may only have the company name, and somebody else could pip you at the post and take your trademark from you.
Oh my goodness. So then you would have paid for the website and everything like that, and then all of a sudden you can't use it anymore.
Correct.
Okay. Very scary thought. Claire, if someone has violated my copyright infringement, what are the next steps?
So we typically start with the letter of demand, where we address the letter to the infringing party and we set out the reason why they've infringed your rights. So from a copyright point of view, that is if you reproduce a work without permission, or you've in any way adapted it, enhanced it, modified it, or copied it. All of these things are infringements in terms of the copyright law. So we would write a letter to the infringing party. We would give them a period of time within which to withdraw, retract what they've created and destroy it, and give you an undertaking that they will not do it going forward. In copyright laws, you have this recourse from a statutory point of view, but it's also a criminal offense to infringe someone's copyright, and you can go to jail if you continue to infringe somebody's copyright and they've given you notice to stop doing that and you don't. So it's very serious, and copyright infringement is taken very seriously by our IP attorneys and also by the authorities, especially when it comes to counterfeit goods. The police and that get involved and often do what do we call these seizures on businesses, where they then take all these counterfeit goods and destroy them based on the fact that they not only infringe copyright, but most times are also infringing trademarks.
Thank you so much. If someone wanted to get hold of you, how would they do that?
The best way to reach me is through my website and send me an email at Waldeck, WALDECK, at Waldeck Attorneys, ATTORNEYS.co.za, or they can send me a message on my cell phone.
Lovely. Thank you so much for being here today and for taking care of these really difficult things that we don't actually think about them ahead of time. We just want to create, get it out there, and there are a lot of serious implications behind it. Thank you so much for watching the Right Then and Earn show. Please click the subscribe button and stay tuned for our next show, where you're going to find a lot more about handling your book writing from a professional basis, because if you treat it like a company, it's going to pay you like a company.